Hello and welcome to the case review regarding recent appellate juvenile court cases. My name is Mark Ells. I'm a research assistant professor at the University of Nebraska at Lincoln. I work at the Center on Children, Families, and the Law. I've been at the center since 1997. I graduated from law school in 1978 and I've practiced in Nebraska and Alaska. And I did this presentation a few years ago. And for the Eyes of the Child initiative, this is an update of that original presentation. We're going to look at several categories of cases today. The first category of cases involves a determination of the best interest of the child in termination of parental rights cases. As you well know, when a court makes a decision regarding termination of parental rights, it has to have found a statutory ground as well as make a finding that termination's in the child's best interest. So the first case we'll look at today, R&D, involved a case where the trial court terminated parental rights regarding Aaron. The termination ultimately was reversed by the Supreme Court. The reason it was reversed was the Supreme Court said that the state had used one witness as a proxy for several other witnesses. The one witness that they did use didn't base her testimony on personal observation, but to a great extent on review of other people's reports and information in the case file. The Supreme Court was concerned that in a case involving termination under the ground that the child was out of the home for 15 out of the most recent 22 months, because that ground operates in a fairly mechanical fashion, the Supreme Court said that courts needed to be particularly vigilant in ensuring that termination was in the child's best interest. In this case, there was some evidence that the child's mother had progressed. She also may have had some limited opportunity to comply because, according to the Supreme Court, she may have had not the full degree of assistance to which she was entitled to under the reasonable efforts requirement. And they said that combined her attempts at compliance, her limited, in their view, limited assistance from the department, and the fact that only one witness testified at the termination prevented them from agreeing with the trial court that best interest of the child had in fact been established, and they, as I indicated, they reversed the termination. Latifah, in contrast, or by way of contrast, was another 15 out of 22 months ground of termination of parental rights case. And in this case, the state presented more than a dozen witnesses. There were over 600 pages of testimony presented. The adjudication or trial of the TPR petition lasted about 3 days. And the court found there was just a vast difference in the extent and relevance and depth of evidence in this case as opposed to that in the R&D case. And they found that there was clearly evidence upon which the court was justified in finding that termination was in fact in the child's best interest. The other ground, or the other issue on appeal, was that the father had asked for a continuance of the beginning of the hearing, the termination hearing, which was denied by the trial court. And the Court of Appeals affirmed that denial of continuance, finding that the child's father had failed to avail himself of proffered assistance from the department in getting to the hearings. He knew when the hearings were and didn't make a very bona fide effort to attend the hearings, and so he wasn't allowed to complain of the court's denying his right, or his request for continuance later on. Also, it weighed heavily in the court's determination that the father was, despite his physical absence from the hearings, was represented vigorously by counsel. And they found that that representation protected his due process rights in this case, and affirmed the trial court's denial of the father's request for continuance. Vanessa and Mario were two of four children to which, for whose parental rights were terminated. The children were out of the home more than 4 years, but I think it was, well, I know it was 51 months total they were out of the home, way in excess of the 15 of 22. The parents had repeatedly failed to achieve rehabilitation over the course of that 4+ years, and there was ample evidence of that termination was in fact in the child's best interest. The court also had denied the parents visitation with the children after the termination proceedings, and the trial court found that that finding was also in the child's best interest, in the children's best interest. Again, a case where there was lots of evidence presented as to why termination was in the children's best interest, and the 15 out of 22 month mechanical, as the court has said, ground was found to be justified for termination. Again, in Jagger L, the Supreme Court talked about the kind of evidence that would sustain a finding of best interest when dealing with a 15 out of 22 month termination of parental rights case. And in this case, it was the father who was complaining about the termination, and the court found that there were essentially four reasons that justified the termination as being in the child's best interest. The first one was that the father had not had any face-to-face contact with Jagger for a long period of time, a matter of years. The father was demonstrably unable to provide a safe and secure home for his child. The court said that the father lived in, quote, a shell of a mobile home. A mobile home lacked plumbing, running water, and electricity. Although he was able, the father also failed to provide health insurance for the child, and the record that the Supreme Court had in front of it reflected the fact that the father was on probation for the offense of lewd or lascivious battery on a child under 16. And they thought that all these things demonstrated that, first, that the child lacked proper care under 43-247-3A. He'd been out of the home more than 15 out of the, vastly more than 15 out of the most recent 22 months. And the evidence demonstrated that the termination based on that ground was in the child's best interest. Sort of parenthetically, the amount of time the child had been out of home constituted more than 70% of his lifetime. Stephanie G., another 15 out of 22 month termination case. This was a case in which the original removal was due to the child living in an unsafe home. The child's mother, in whose care she had been, was developmentally delayed. There was evidence at the termination trial that her cognitive functioning wouldn't improve, and while there was some chance that the mother would be able to, with very substantial support, she might have been able to provide a safe and adequate home for the child. The evidence was really, the evidence really demonstrated that that was highly unlikely. and that it would be a great challenge for the mother, that it would be quite difficult without a great deal of outside help and support, and that those disabilities under which the mother operated just weren't going to go away. And she had also been out of, the child had been out of her home since the original removal more than 28 months without any significant progress towards rehabilitation, which the court found justified the termination as being in the child's best interest. Xavier was another one of these 15 out of 22 months in which, again, the court is going to be extra vigilant in determining whether there was the evidence justified a finding that the termination was in the child's best interest. And in this case, the Supreme Court reminded everybody that parental rights can't be terminated unless the state can rebut the presumption that a parent is a fit parent. And in this case, they found that that presumption was not rebutted, was not overcome. This case involved a situation in which the mother had been originally unable to provide some particular medical care for one of her children. She subsequently learned how to provide that medical care and was able to demonstrate that. And the reason and she had two other children for whom she was caring, so there was evidence that she was in fact a fit mother, and in addition to the presumption that she was a fit parent. And the reasons that the department and ultimately the trial court found to terminate her parental rights, why it was in a child's best interest, is because she wasn't very good at time management, budgeting, organization, and implementation of a timeout technique. She wasn't I should say she was an adequate parent to her other two children, as I said, and the original reason for the removal, i.e. her inability to provide certain medical care, had dissipated because she had learned how to do that. And so the Supreme Court said, look, in this case, what started out as a fairly minor thing seemed to sort of snowball over time, but when we get back and look at the original reason for removal, the mother has rehabilitated herself as to that. These other things are fairly minor, the time management, the budgeting, etc., were fairly minor and didn't really affect safety of the child. And we can't expect parents to be perfect parents, and all those things taken together resulted in a reversal of the termination of parental rights. In Hope L, this was not a 15 out of 22 month termination. This involved the ground in 43-292 paragraph 9, chronic abuse, and the issue was whether the parents were entitled to reasonable efforts to reunify them with their children. And in this case, this was although not described as this way necessarily, it had elements of Munchausen syndrome by proxy behavior. In other words, parents were repeatedly seeking unnecessary medical attention for their children. That attention resulted in the performance of several unnecessary procedures and surgeries on the children. They were both convicted of, both parents were convicted of felony child abuse for withholding food from Hope's brother Xavier, to the point where he actually started to exhibit starvation symptoms. So in this case, the court said that not only was there ground under the chronic abuse, but they were also guilty of substantially and continuously or repeatedly providing parental care and protection under 43-292, parent 2. And because of the chronic abuse finding under paragraph 9 of 292, the Supreme Court said it was not necessary for the state to provide reasonable efforts at reunification for these parents, and that the evidence clearly established that termination of parental rights was in the children's best interest. Cardale is almost the flip side of the Hope L case, in that in this case the father of Hope was alleged to have been in possession of a small amount of crack cocaine, and that was the sole ground for finding that he was that the child was abused or neglected. He was adjudicated under 247 3A on the ground that being in possession of drugs constituted a risk of harm to the child. But as the Court of Appeals pointed out, the state did not provide any evidence that the father was actually charged with the offense, let alone convicted or incarcerated for the offense. The statute of which was allegedly, or which he was accused in the petition, that had no minimum prison term. The state didn't provide any evidence at the adjudication hearing as to whether the father had any prior history of drug use in any way, either in the presence of the child or away from the child, or they had any other prior drug or alcohol related offenses, whether when the juvenile was present. There wasn't any evidence that Cardale was affected in any way by his father's actions, or whether there was any, there just wasn't any information that would allow a court to make an inference that the father's actions presented the child, or presented any risk of harm to the child. And they said, and I'll just quote a line from the opinion, based only upon an exhibit showing that Cardale, the father, had a controlled substance in his possession, and without any evidence of charges filed or a sentence imposed or any impact on the juvenile, the risk of harm to the juvenile can't be considered definite, and the adjudication was reversed. The next category of cases deal with the Indian Child Welfare Act. The Indian Child Welfare Act is enacted both in federal and state law, and provides certain protections to Indian children based on a number of considerations, notably tribal sovereignty and the historical record of Indian children being removed at a unjustifiable rate from their home. So first Congress and then the Nebraska legislature enacted the Indian Child Welfare Act to afford Indian children certain protections to prevent unwarranted removal from their parents or their tribe. So the first case we'll look at, Brittany C., involved a couple of different things. One was, in this case, the tribe had not only intervened, but had asked to have jurisdiction transferred to the tribe, which is under the Indian Child Welfare Act. If a tribe or a parent asks for transfer to the tribe of which the child is either a member or eligible for membership, if his parent is a member, the presumption is that the case will in fact be transferred, and there has to be a good cause established not to transfer the case to tribal jurisdiction. So there are a couple issues in Brittany's case. First, was the denial of the tribe's motion even a final order that could be appealed? And the Court of Appeals answered that question in the affirmative, saying that because the denial of the request to transfer to tribal jurisdiction affected a substantial right in a special proceeding, i.e. a child protection proceeding, that constituted a final order which could in fact be appealed, even though other aspects of the case lay in the future. And the second question was, can the doctrine of forum nonconvenience constitute that good cause for denying a request to transfer to tribal jurisdiction? And the Court of Appeals answered the second question in the affirmative as well, saying that if in fact there are facts justifying it, then forum nonconvenience can in fact justify good cause. And in this case, the facts underlying the supporting of the finding of forum nonconvenience were that neither the parent or her children lived on the reservation to which transfer was sought. The tribal court or on the reservation was approximately 2 hours from the courthouse in Scotts Bluff. The testimony about whether there was even a mechanism to subpoena witnesses to appear in the tribal court was unclear. When the tribal court clerk was asked about getting people to testify, there was testimony that had never happened in the witnesses' experience. So because the family wasn't domiciled on the reservation, because transfer wasn't mandatory, because there was good cause for retaining jurisdiction, there was no abuse of discretion in denying the tribe's request to transfer. And again, the principle is that the motion to transfer is to be granted unless there's good cause. And in this case, what the Court of Appeals was saying was there was in fact good cause, and the good cause is what I just talked about: the distance between the state and the tribal court, lack of a mechanism to get witnesses to the tribal court if the case was transferred there, and the fact that it had just never happened before, but getting witnesses to the tribal court. Phoenix L involved a couple of questions, but the most important one really was the child's mother, who the child's mother was not Indian, claimed that granting Indian children special rights or protections, actually, as the Indian Child Welfare Acts of both the federal government and the state of Nebraska do, violated equal protection. And the Supreme Court in Nebraska said that the statute does not violate equal protection because the special protections granted to Indian children are not based on race. It's not a racial matter, but the statute is based on and attributable to the historical sovereignty of Indian tribes. So it's not a racial distinction. The second question, which was sort of peripheral, but I think it's important to talk about just briefly, was the father had timely appealed his TPR, and since there was some overlap of the two cases, the mother was arguing that the Court of Appeals, or that the trial court didn't have any jurisdiction. But the Supreme Court here said the two cases were distinguishable. They were separate cases. They were individual cases, even though there was some overlapping evidence. And the fact that the father's case was on appeal didn't divest the trial court of jurisdiction over the mother's case. Enrique involved again, this is under the Indian Child Welfare Act. In Indian child welfare cases, the state has to afford parents not just reasonable efforts, but active efforts to rehabilitate or to achieve reunification. And in neither the federal statute nor in the state statute is the term active efforts anywhere defined. And so a couple of questions came up. One was what is the burden of proof when establishing active efforts in this case? And the Court of Appeals found that the correct burden of proof was clear and convincing evidence that active efforts had in fact been made to prevent the breakup of the family. They went on to list those efforts, and because they had to talk about that in order to talk about whether the burden of proof was met. So in this case, active efforts included therapy, placement, case management, psychiatric and chemical dependency evaluations, visitation services, transportation assistance with visitation, parenting and domestic violence classes, random urinalysis, and all those efforts at reunification proved to be ultimately unsuccessful. The other thing was that typically in Indian child welfare cases, in order to prove the likelihood that continued placement of the children with the parents will result in serious emotional or physical damage, there needs to be expert testimony to support that. There was no expert testimony in this case, and the parents complained about that, but the Court of Appeals said that in this particular case, the mother hadn't challenged the continued out-of-home placement of the children, so no expert testimony was given regarding the likelihood that continued custody with her would result in serious emotional or physical damage. But the court also noted that evidence provided by the state at the dispositional hearing did in fact clearly and convincingly support that finding of harm, even though it was not provided by an expert. The evidence had been provided and reached that level. The parent, the mother, also asserted that the juvenile court, the trial court, had erred in denying her motion to dismiss, and she had moved to dismiss because of she claimed that the trial court had applied the incorrect burden of proof at the adjudication hearing, and therefore the trial court never acquired jurisdiction of the matter. But first, the Court of Appeal said, well, in the first instance, the adjudication was sustained by the proper level of evidence, and secondly, she had not directly appealed the adjudication order within 30 days as required by statute. So she couldn't now collaterally come back and complain about and allege a lack of jurisdiction, because she would be in essence arguing about facts which had been firmly established by the court's finding at the adjudication hearing and her failure to timely appeal that. So she just had lost the ability to complain about that by not filing the appeal. In Walter W., the Supreme Court addressed the issue of what is the proper burden or the level of evidence that has to be established to prove that active efforts were provided parents to prevent the breakup of the Indian home. And the answer to that question, the Supreme Court said, is that it has to be established by clear and convincing evidence. The parents had argued that it should be beyond a reasonable doubt, and the Supreme Court essentially said, well, look, if Congress or the legislature in Nebraska wanted a higher burden of proof than is typically required at a 43-247-3A adjudication hearing, they would have said that, and they didn't say that. They didn't specifically say that there had to be proof beyond a reasonable doubt at the adjudication phase. And again, the issue of what are active efforts came before the Supreme Court, and they said that whatever active efforts are, we know that they need to be more than what we would call reasonable efforts in a non-ICWA case, and we know that some of the efforts need to be culturally relevant. They said that there's no precise formula for active efforts, but finding whether active efforts have been applied requires a case-by-case analysis. The Supreme Court noted that in this case there was quite a lengthy list of services provided to the parents, including, again, chemical dependency treatment, both inpatient and outpatient, job skill development, psychological and psychiatric referrals, housing assistance, vouchers for rent, clothing, utility bills, transportation, foster care was provided, and medical care for Walter was provided. And all those things constituted active efforts. And again, what was the burden of proof for proving best interest was similar to proving active efforts, clear and convincing evidence. And it does not need to be, does not need to include the testimony of a qualified expert witness. And that finding, that it didn't require the testimony of a qualified expert witness as to the child's best interest, was distinguishing or disapproving what the Supreme Court in this case said was dicta in CW, a 1992 case that they had decided, which seemed to require proof not only with an expert witness, but it had to be beyond a reasonable doubt. So they were clarifying the appropriate burden of proof for best interest is clear and convincing. Elias involved a case in which an Indian child welfare specialist for the Ponca tribe of Nebraska filed a motion in the trial court to intervene. None of the parties objected, but the trial court refused to let the tribe intervene because it said that the motion was filed under what constituted the unauthorized practice of law. So the case was obviously appealed, and the Supreme Court answered this question: are non-lawyers authorized to file pleadings in Indian Child Welfare Act cases? They answered the question in the affirmative, saying that tribal participation in state custody proceedings involving Indian children is essential to achieving the goals of the Indian Child Welfare Act, and the tribal interest represented by the Act and the tribe's right to intervene under statute outweigh any interest the state has in preventing the unauthorized practice of the law under Section 7-101 of the Nebraska Revised Statutes. So they talked about the preemption test, which interest is a higher or more important interest, and they found it was the interest of the tribes to protect their children, more important than preventing the unauthorized practice of law. So bottom line is that in Indian child welfare cases, non-lawyers are allowed to file pleadings on behalf of an Indian tribe. In Lewis S., the Court of Appeals addressed the question of whether a qualified expert witness, which is required for some of the testimony in Indian Child Welfare Act cases, and the definition of what's a qualified expert witness is in the statute, but it's not a comprehensive definition. In this case, the qualified expert witness proffered by the state was not Indian, and that was the point of contention. And in this case, the Court of Appeals said that a qualified expert witness doesn't have to be Indian as long as they're familiar with tribal cultural matters. And in this case, the expert, who is Evelyn Labode, who used to be a lawyer in Nebraska, who did a lot of training about the Indian Child Welfare Act, was very familiar with Indian culture, had testified in several cases as a qualified expert, met the definition of a qualified expert witness. There was the tribe had asked for transfer again of this case, and it had been denied. The trial court found that the good cause for denying transfer was that the tribe hadn't intervened for 2.5 years. And that was seen as part of the as establishing good cause. They also said in this case that the cultural relevance aspect of active efforts is not mandatory in cases in which there's no nexus between any aspect of Native American culture and the shortcomings or faults and habits of the parent when there's no relation or nexus between the two. So if there's a cultural aspect to the shortcomings, then the active efforts have to include a cultural relevance piece, but otherwise they do not. In this case, the qualified expert witness testified that the children's involvement with their native culture was very limited. The tribe didn't even become involved in the case for 2.5 years. All this weighed with regard to the requirement of cultural relevant aspects of active efforts. And the Court of Appeals said, and I quote, "We see no nexus between Native American culture and either the parental shortcomings or the solution thereto." And in this case, that's a close quote. In this case, the faults and habits involved really a filthy, very unhealthy, unsuitable living conditions, coupled with the mother's addiction issues and the father's incarceration for violation of criminal law. So the termination of parental rights was upheld in this case. Emma J., you see this is the first Emma J. case. And again, we're talking about a case under the Indian Child Welfare Act, and again they address the issue of what's the appropriate burden of proof, level of proof at an adjudication under 43-247-3A, and the answer to the question according to the Court of Appeals in this case was that it's a preponderance of the evidence. The other question that came up was, is expert testimony required? And they said that the statute does in fact require expert testimony at the adjudication phase, and in this case it wasn't presented. So they reversed the termination in this case. But the state asked for a rehearing, and the Court of Appeals reversed itself and found that the failure of the court to find that active efforts had in fact been presented and that there was expert testimony to support a finding of serious harm to the child. They noted that in the first case they had not realized or understood that those issues were addressed at the original adjudication hearing. They were looking only at the disposition hearing and didn't see those requirements met. So they said because they were addressed at the adjudication hearing, we're going to find the failure to address them at the later hearing to be harmless error, and they reversed their finding. In this case, the TPR, the termination of parental rights, was reversed because active efforts had not been provided the parents as required under the Indian Child Welfare Act. The reason that there hadn't been any active efforts, in fact any efforts at all really, was because the trial court had found that there were aggravating circumstances under 43-283.01, which relieve the state from its obligation to provide reasonable efforts when those aggravating circumstances are present. And the court said, well, aggravating circumstances and active efforts are two separate things, and that the fact that in non-Indian Child Welfare Act cases the state is excused from providing reasonable efforts doesn't carry over into Indian child welfare cases and excuse the state from providing active efforts. They're two different statutes, and they have two different intents, and they said that the existence of aggravating circumstances did not excuse the state from providing active efforts at rehabilitation in a case which involved the Indian Child Welfare Act. This is a interesting case. It's out of Utah, so it's not particularly relevant to Nebraska practitioners, but it does address an interesting question. What happened in this case was that a biological mother of a child relinquished her parental rights to a child, and the procedural safeguards under the Indian Child Welfare Act were not followed. And the tribe and the child's mother was trying to have the adoption and the TPR vacated because the Indian Child Welfare Act wasn't followed. But it was a unique case because the child's biological grandmother was what is called, quote, original enrollee, close quote, of the Cherokee Nation. The Cherokee Nation enacted a statute called the Cherokee Nation Citizenship Act, which provided that every newborn child who is a direct descendant of an original enrollee was automatically admitted to citizenship in the nation for a period of 240 days. The child's, as I said, the child's biological grandmother was an original enrollee in the Cherokee Nation, but she, the grandmother, had never enrolled the child's biological mother in the tribe. And the Circuit Court of Appeals in the 10th Circuit, the Federal Circuit Court of Appeals, found that act enacted by the sovereign nation of Cherokee Nation did not bestow on this child the status of being an Indian child, because although under tribal law he was a citizen, the Court of Appeals for the 10th Circuit said that temporary membership wasn't what ICWA had in mind when it was protecting Indian children. And the 10th Circuit Court of Appeals saw this as sort of a sham by the Cherokee Nation to extend its reach. I think it's just an interesting question, and we'll see what happens if it gets appealed to the Supreme Court of the United States. But to me, it flies in the face of the whole idea underlying the Indian Child Welfare Act that tribes are sovereign nations, and if they say a person's a citizen, they're the ones that get to say that, not the 10th Circuit Court of Appeals. But I could be wrong, and we'll find out if it gets appealed to the Supreme Court. This case was just decided in April of 2011. So again, to me, it's an interesting legal issue, not directly relevant to Nebraska practitioners unless you are dealing with the issue of whether a child is in fact an Indian child. And there may be, although I think it's pretty iffy, there may be things in the case Nielsen versus Ketchum that you want to look at if the issue is this child an Indian child. To me, the safest course, because the ramifications are pretty far-reaching, if a child turns out to be an Indian child and the Indian Child Welfare Act wasn't followed, you can have vacation of a TPR or relinquishment and an adoption several years after those things happen, which of course is very disruptive on another number of levels for children and parents and adoptive parents. It would seem to me the safest course is to err on the side of caution and treat children as Indian children if there's any real possibility that finding will disrupt things later on. Sorry, advance the slide. So the next group of cases that we're going to talk about involve the jurisdiction or the power and authority of the juvenile court. And we're only going to look at a few cases, but again, this is the sort of threshold question. Does the court have jurisdiction? Is it personal jurisdiction? Is it subject matter jurisdiction? And when does that attach? Because they're threshold questions, they're pretty critical to following the right procedure in juvenile cases. So the first case, Devin W., involves the issue when does the court obtain subject matter jurisdiction? And what happened in this case was that the mother was adjudicated, but the custodial father was not mentioned in the petition. And later, the court took action with regard to the father's rights as well as the mother's rights. And the case was appealed. The Court of Appeals reversed the trial court, saying there wasn't any jurisdiction over the father because he hadn't been mentioned in the original petition. It was only the mother. So that case was appealed by the state up to the Supreme Court. And what the Supreme Court said in Devin W. was that when a parent is adjudicated, the trial court obtains subject matter jurisdiction over the child, and that therefore any under 43-247-5, that's 43-247 parent 5, any parent, guardian, or custodian who has custody of the child also comes under the subject matter jurisdiction of the court. So in this case, the father was in fact within the jurisdiction of the court, and the trial court was justified in taking action with regard to his rights, to his custodial rights to Devin. So the whole thing of, I think it's important to know the definitions that are in the statutes, and the Supreme Court here clearly said as much. All right. Kevin K. is a very interesting case because what happened was that Kevin was adjudicated to be a status offender essentially because he was a truant, and he was kept at home, but he was under the state's jurisdiction. When he turned 16, his mother took him down to the high school and withdrew him from school, which she is now allowed to do under Nebraska Statute 79-201, parent 3, parent D as in dog. This was a lawful withdrawal from school, and then what happened after that was that Kevin, well, his lawyers obviously, went back to the juvenile court and asked the juvenile court to dismiss the case against him because they said that he could no longer be under the court's jurisdiction. He was withdrawn from school in a legal manner. Therefore, it was lawful. It was impossible for him to be a truant. If you're not in school, you can't be truant from school. And the trial court said, "That's right. I don't like it. I think this kid needs to be under my jurisdiction. I think he's going to have trouble later on, but I don't have any power or authority over him because of this new statute and because his mom followed the procedures." And so she said, "I don't have to get to whether it's in his best interest. I can't get to that question because I don't have any jurisdiction over him." So if it was simply a matter of is it in his best interest, she would have answered that question no, but she couldn't get to that question in her opinion because of the operation of the statute. So the state said, well, that's not a good outcome. So they appealed it, and it got to the Supreme Court, and the Supreme Court affirmed the trial court. They said that lawful discontinuation of school enrollment necessarily ended the juvenile's status as a truant, which was the sole basis of his adjudication. So if kids are legally withdrawn from school, they can no longer be truant. So the next case is Taylor, which involves what's a final order and what is a final order that can be appealed. So first, there was a pre-adjudication detention or placement order removing the child from home. And the question to the court was, can that be appealed? And the answer was yes. That's an appealable order because it affects the substantial right of the parent. And then the second question was, if there's a series of similar custody orders, can a later order be appealed if more than 30 days from the original order has elapsed? And the answer to that question was no. The final order was the first one, and then if you don't appeal that one, the other orders simply continue that, and you've lost your opportunity to file your appeal. So the answer to the first question is yes, and the answer to the second question really is no. Again, the final order was the prior order, upon which the later orders were based. There are again a small number of cases that involve immigrant issues, both in different contexts. So this first one, the mother of the child was deported. The child was kept here. Parental rights were terminated because the mother couldn't comply with the case plan and couldn't rehabilitate herself. So a number of questions came up. The first one was, when a parent is deported, does the state lose jurisdiction because there's federal preemption? And the Supreme Court of Nebraska answered that question in the negative, reminding people that family law matters are traditionally state matters, and the state keeps jurisdiction of those family matters even when there's an immigration or deportation issue involved. Another question was whether the Vienna Convention, which requires notification of a foreign embassy, if that statute is, or that treaty is violated, does that automatically result in a denial of due process to a parent? And the court said, well, in this case, we don't say whether complying with the convention is a jurisdictional prerequisite, but the trial court found that the convention was in fact complied with in this case, and we don't think that finding was erroneous. So we're not going to get to the weightier question. We're going to find that the court had good reason to find that the treaty was in fact complied with. And the second one had to do with whether if the state doesn't comply with 483804, which also requires notice to a particular government in a certain length of time, if that's not strictly complied with, is the juvenile court divested of its jurisdiction? And the answer again was no, that the trial court still has jurisdiction. So the Supreme Court found that the trial court, juvenile court, had jurisdiction, even though the mother was being deported, that the state had in fact complied with the Vienna Convention, that the statute 43384 requiring the department to notify appropriate counsel, is not a jurisdictional prerequisite. And finally, they said, all those things being what they are, in this case, the evidence was insufficient to establish that termination of the mother's parental rights was in the best interest of the child. What had happened originally was that the mother had taken the child in for a medical checkup. The child had a respiratory illness. She was given directions on what to do to take care of the child. She didn't follow those directions to the letter of law. The child got worse, And that's what resulted in the removal, and ultimately the mother, because she was here illegally, was deported. The child was kept here. Mother tried to set up a rehabilitation plan in her home country of Guatemala, went to some great lengths to comply with the case plan, but couldn't strictly comply with it because she was in Guatemala. And the Supreme Court said that her failure to provide medical care in 2 isolated instances didn't warrant termination of parental rights. And the fact that she wasn't able to comply with the court order didn't warrant termination by itself. So they reversed the termination, and the child was eventually reunited with her mother in Guatemala. Antonio and Gisela, again, the issues came up with regard to compliance with the 3804, the statute that required the state to notify the appropriate consulate of the child's country or the parent's country of origin. And the parents in this case complained that because the state didn't do that, they were denied due process. It wasn't so much a jurisdictional thing as it had been in the Angelica case, but that the failure to abide by 43284 or 384, excuse me, affected denied them due process. And the court in this case said non-compliance did not affect the parents' due process rights. They did go on to note, however, and I think this is important because there's no certainty as to how the courts are going to view the department's ongoing failure to comply with 3804. The Court of Appeals said, quote, "We cannot help commenting that DHHS should put in place procedures to ensure that the dictates of 3804 are followed." So again, it's not that it's a dead issue, but in this case, didn't result in a denial of due process for these parents. And termination of parental rights in this case was warranted. It was in the children's best interest because there was domestic violence between the parents, and the mother was unable to protect the child. The domestic violence occurred even after the petition was filed. So the court upheld the termination of parental rights in this case. The authority of the juvenile court, the extent to which the juvenile court can order parties to engage or not engage in particular practices, behaviors, or activities is the sort of subject of the next group of cases we're going to look at. This is different than the power of the court, the jurisdiction of the court. This is to what extent can that jurisdiction be exercised when it exists in the first place. Heather R. involved several issues, but I'll talk just first about whether due process was denied the parents in this case. And the Supreme Court said in this case that the parents were in fact afforded due process because they had notice of the hearing, they had a fair hearing, they were represented by counsel in effective ways. We'll get back to that in a second, the representation issue. They were also, the parents also complained that they were not afforded the services of an expert to provide a second opinion as to harm to the child. And the Supreme Court said in this case that that was not a denial of due process because the parents were able to confront and cross-examine the state's witness. They did in fact present evidence on the same point that a second expert might have provided evidence, and the second opinion wasn't likely to have cast doubt on the proceedings due to the strength of the state's case. Furthermore, the parents were jointly represented in this case by a single counsel, and that was not a denial of due process because their interests were so intertwined. They were not distinct in this particular case. So their due process rights were not violated. The Supreme Court also noted in this case that it was important to keep in mind that the adjudication and the dispositional phases of a juvenile proceeding serve two different functions. They said in the adjudication phase, the rights of the child to be safe are being looked after, and in the dispositional phase, the right of a parent to the care and custody of his or her child is being looked after. That's the issue that's involved, which gets back to the due process issue with regard to representation by counsel. This is they said this is not analogous. The adjudication phase is not analogous to a criminal proceeding and the effective or ineffective assistance of counsel cases, because it's not the rights of the parent that are at risk at the adjudication phase. It's the rights of the child to remain safe. So the adjudication phase of a juvenile proceeding is not analogous to a criminal proceeding against an adult. And that's why the analysis of whether representation is effective or not is different in a juvenile case than in a criminal case. And in this case, they found that whatever the level of effective counsel might be, if we to ever get to that, it was present in this case in any event. This was just be clear. This was the appeal from the adjudication phase of the proceedings. Elizabeth S. involved a case where a county court had some sort of proceeding. The appellate court was at a loss to name the hearing, or even if it was in fact a hearing of some sort. But what happened was there was a custody order in a divorce case in place, and one of the parents wanted to get that modified sort of through the back door. So they went to county court and had essentially a juvenile court proceeding where the trial court talked to witnesses without any counsel being present, and there was no sworn testimony taken on the record, and the trial court even made a point of saying this is not a formal hearing, and we're not taking evidence, but I'm modifying the prior order. And the other parent objected, and well, let me back up. I'm mixing my cases up. In Elizabeth, the order that was in place was imposed by a juvenile panel, the 3-judge panel. And the trial judge, who was not a member of that panel, wanted to modify that order in order to let the child who was the subject of the hearing travel out of state. So to get to that point, he talked to some witnesses, including an expert witness who said letting the child travel out of state wouldn't be harmful to the child, etc. But there was no record, there was no sworn testimony taken, and the Court of Appeals said, look, in the first place, since there was no evidence, you can't change the department's plan. And the department's plan was the one that was authorized or approved by the 3-judge panel, because it's, at least it used to be, before 2011, presumed to be correct, and you had to overcome that by the presentation of evidence. So since no evidence was adduced, he couldn't change the 3-judge panel's approval of the department's plan. Secondly, and probably in some ways even more importantly, the Court of Appeals said when a judge engages in ex parte contact with of any sort. They need to recuse themselves from any participation in any matters regarding that hearing. And so they reversed the trial court's order allowing the child to travel out of state in this case. But it was one of those it's one of those one of those proceedings where you just wonder what was going on when the parties aren't present. The judge is talking to witnesses and modifies an existing order of a 3-judge panel. So Court of Appeals clearly said, don't do that. In Chloe and Ethan L., parental rights as to 2 children were terminated under 43 292 parent 2, which again is that continued or substantial neglect. And they were also found to have the grounds of felony assault on another child. And what happened was that Ethan was seriously injured. And you can see his injuries if you go and read the case, but they were substantial. He had multiple fractures throughout his body, which were in various stages of healing. And essentially, the parents had no satisfactory answer for those serious injuries. They blamed a sibling. They also claimed that the injuries were accidental. Multiple doctors testified that there was simply no way that the injuries were accidental or that the young sibling could have inflicted these injuries. And the Court of Appeals said that those circumstances warranted termination of parental rights, and that the parents were not entitled to any reasonable efforts at reunification. So that's how. So again, termination of parental rights has 2 siblings arising from the unsatisfactory explanation of serious injuries to one of the 2 siblings. Justified the termination of parental rights. In Veronica H., it was one of those cases in juvenile court which aren't unusual, which kind of seem to not proceed in an orderly fashion towards a resolution of any sort. And in this case, the trial court determined that the case manager simply didn't have the knowledge or experience to handle this complicated case. And the trial court ordered the department to assign a different case manager. The department appealed that order, saying that it was beyond the authority of the court to do that. And the Supreme Court upheld the trial court and said that the trial court has authority because under 43-285 parent 1, as it used to be written, the department has the authority by and with the assent of the court to determine the placement and care of the juvenile, placed in its care and custody. And the because of the authority under 43-285-1, the court could order the department to assign a different case manager. The juvenile courts were given the power by the legislature to assent, and the court said by implication to dissent from the placement and other decisions of HHS, and that authority remains intact, even in 2011. Destiny A involved again a termination of parental rights. The Supreme Court ruled that when the trial court heard evidence regarding the availability of an adoptive placement, it was an error. It should not have heard that, should not have listened to that testimony, because statute 43-292.02 parent 2 expressly provides that when deciding whether to terminate parental rights, a court should not consider that an adoptive family has been identified. And the Supreme Court said that it had erred when it decided Phoenix L, and said that one of the things they said, even though it wasn't an issue in the case in Phoenix, the Supreme Court in dicta said that the children's foster family wished to adopt the children, and the Supreme Court said in this case, in Destiny L, to any extent that they relied on that sort of evidence in the prior case, we're disapproving that language. So the statute is clear, 43292.02 parent 2. We can't hear that evidence. But in this case, it was harmless error. Child had been out of its home, her home, all her entire life. There was also some hearsay that was improperly admitted regarding the children not wanting to go on visits with their mother. But that improper admission of hearsay, recognizing the rules of evidence the formal rules of evidence don't apply, there was a contention that this violated due process, and the Supreme Court said not in this case. Due process was not violated because the witnesses were thoroughly cross-examined, and other witnesses said essentially the same thing. So the hearsay evidence amounted to sort of cumulative evidence and didn't amount to a violation of the parents' due process rights. Joel Anaya involved, as you can see, the statutes under 71-524 that require children to be newborn children to be screened for particular illnesses. In this case, whoops, did I go too far? What happened here? Here we go. In this case, the parents complained that the statute was a violation of their First Amendment freedom of religion. The Supreme Court said no, it's not a violation of, doesn't involve a freedom of religion violation. But when parents don't comply with the statute, that non-compliance by itself, they're not excused from that because of religious reasons, but non-compliance with the screening statute doesn't in and of itself constitute a reason to adjudicate a child under 43-247-3A, because there's, in this case at least, there was no showing that non-compliance with the screening statute placed the child at immediate risk. In fact, the child was, several weeks had gone by. There was testimony that by this time the danger of non-screening sort of had passed. There wasn't any emergency situation. There was no reason to continue the out-of-home placement of the child. So they essentially said there may be cases in which failure to comply with the screening statute constitutes a risk of harm to the child, but not in this case. And therefore they reversed the adjudication and sent the child home. Ethan M. involved, this is the case that involved the divorce decree. Got ahead of myself a while back. So what was going on in this case was that the child was in, Ethan was in his dad's custody pursuant to a valid divorce decree. There was a TPR case against the father. The Court of Appeals subsequently reversed the TPR and ordered the department to make efforts to reunify the child with his father. The county court adopted a case plan which severely restricted Ethan's father's visitation and placed the child in Ethan's mother's custody, and then dismissed the juvenile court case. And what the Court of Appeals said in this case was, look, you can't modify a permanent child custody order by adopting the department's case plan in a juvenile case. They should have, the county court could have and should have exercised jurisdiction if it was going to modify custody because the child was within the court's jurisdiction because the court had made a valid adjudication under 43-247-3A, but it didn't exercise that jurisdiction. There was no proceeding that resembled a custody modification proceeding. And there was no complaint to modify, there was no parenting plan, there was no support order. The order that the court entered, because it dismissed the case, actually had the opposite effect of what it intended to, because when it dismissed the juvenile case and didn't enter any order having a permanent effect on Ethan's custody, it lacked the ability to enforce that order of placing the child with his mother. So the only remaining effective order was the divorce decree. And under that decree, the child had to go back to his father, which was not what the county court intended. But the county court didn't follow the procedure required by law. And it's not really explicitly stated in this case, but there was an implicit recognition of the fact that the trial court essentially evaded the Court of Appeals order on remand, because the order on remand was that they were supposed to attempt reunification with the father, and that was not what the court wanted to do, the trial court wanted to do or tried to do. It's what ended up happening. Because the parties and the county court didn't follow the right jurisdiction to modify a permanent custody order. All right, Preston and Crystal involved termination of parental rights of siblings when the ground of termination was under 43-292 parent 5, having to do with the mental condition of the parent. And under 43-292.01, when termination of a parent-juvenile relationship is sought under that subdivision of 292, it says that the court shall appoint a guardian ad litem for the alleged incompetent parent. The trial court did not appoint a guardian ad litem for the parent, even though obviously there was a question about her competency to stand trial. And the Court of Appeals said that was a plain error and reversed the TPR in this case. Said the statutes are very clear. If you're going to proceed under 43-292 parent 5, you have to appoint a guardian ad litem. Failure to do that is harmful error, and we're going to reverse the TPR. In Gabriella, the issue was the court's authority, as you can see, to order the department to accept the voluntary relinquishment of parental rights. In this case, there was a finding under 43-247-3A, and both the deputy county attorney and the guardian ad litem agreed that the appropriate permanency objective was adoption. One of the reasons being that both parents were willing to relinquish parental rights. However, the department was refusing to accept relinquishment because it didn't yet have a permanent home for the child. And the department apparently also had expressed concern to the guardian ad litem and to the county attorney about accepting a relinquishment when a parent was paying, quote, a substantial amount, close quote, of child support. Because once the relinquishment was accepted and the child was in the department's custody, the parents would no longer have to pay that child support. And the the court ordered the department to accept the voluntary relinquishment of both parents' parental rights. They refused to do that. They appealed it to the Supreme Court, and the Supreme Court said yes, in fact the court does have the authority to order the department to accept that voluntary relinquishment under both 43, 284, and 285, again dealing with the assent of the court and the authority of the court to withhold that consent or that assent from the department's plan. The next series of cases, and again it's just I think there's just a couple of cases in this section dealing with standing. And this first case is an unpublished case, but seems like a significant issue to deal with, having to do with does a foster parent, not an adoptive parent, but the foster parent, have the standing to object to a change of placement and to appeal a change of placement order. And the Court of Appeals answered both those questions in the affirmative. Because under 43 2106.012C, an appeal from a dispositional order may be taken by certain persons, including, quote, the juvenile's parent, custodian, or guardian. And for purposes of this subdivision, again I'm quoting, custodian or guardian shall include but not be limited to the department, an association, or an individual to whose care the juvenile has been awarded. And clearly a foster parent is somebody to whom the child's custody has been awarded. So they have the authority or the standing to appeal both the change of placement, but in the first instance to object to the change of placement. But interestingly, they don't have sufficient interest to warrant intervention as a party in the case. So they don't have a right to intervene, although they have the right to make this objection and the right to appeal. So it's a very limited ability to participate in the hearing. The ability being, their standing being limited to the ability to present evidence as to their fitness and qualifications to remain as foster parents, and then to appeal that, to appeal an order removing that from them. Hammett versus Hammett involved, as you can see again, grandparent visitation. The statute, which is 43-1801 through 43-1803, was held to be constitutional in this instance, and that they also found that in this instance the trial court didn't abuse its discretion in awarding visitation to these grandparents. But they went to some length to point out that when grandparents intervene or ask for visitation under this statute, they have the burden to prove by clear and convincing evidence that there's a significant beneficial relationship with the child, that it's in the child's visitation. Again, this is not custody, this is visitation. Visitation's in the child's best interest, and that there's no that won't result in any adverse interference with the parental rights of the parents. Remembering that parents have the parental fitness presumption is a very strong principle in Nebraska jurisprudence. So while grandparents have these rights granted by statute, they do to some degree conflict with parental rights, and this is how the court's going to resolve them, by requiring this the grandparents to prove by clear and convincing evidence those three issues: significant beneficial relationship, best interest, and no adverse interference with parental rights. The next series of cases involving guardianship of children, I think, is very important. There's some pretty clear principles established in these next four cases, and these are the last four cases, so stay with me. Because guardianship is frequently the permanency outcome of a juvenile court proceeding under 43 247 3A. So This first case involving DJ is very interesting. The presumption, the parental preference principle. In this case, what happened was that the mother had early on asked her parents, or grandparent of DJ, to watch over her child, and actually had them appointed guardians for DJ. And that was established. 3 years later, she had achieved financial security. She was emotionally capable of being a mother, she believed. So she sought to have the guardianship, which was established at her instance, dissolved. The trial court essentially said, "Hey, you've given up your parental rights. You've forfeited your parental rights by establishing this guardianship with your parents, the child's grandparents. The child's been doing really well with the grandparents, and there's no reason to disturb this stable relationship at this point, because you've been out of the picture for 3 years." Well, she really hadn't been out of the picture for 3 years entirely. But regardless of how much she'd been out of the picture, when she came back into the picture, the issue should have been, was she then a fit parent? Because the parental preference principle dictates in Nebraska that before you can take rights away from a parent, you have to establish that they're unfit at that point. And the excuse me, the Supreme Court said that in this instance that hadn't established, and the parental preference principle required that the guardianship be dissolved or terminated, and that the child be returned to his parents. Sorry about the cough. Antonio and Priscilla, this is a case in which I think the trial court was trying to sort of cut the Gordian knot, or find a creative solution to a problem. And what they ended up doing in this case was transferring custody, legal custody, from the department to a guardian, but transferring physical custody from the department to the guardian. But the trial court said, we're allowing the department to keep legal custody of the child so that the child will qualify for former ward benefits. And that sort of arrangement had been something that the guardian ad litem and the attorney for the children had thought was in the children's best interest. And the trial court said, well, we didn't think that they could do that. So the guardian ad litem ended up appealing this and trying to get that arrangement set up. And the Supreme Court said, you can't do that. When a guardianship is established under the juvenile code as a means of providing permanency for children who have been adjudicated, then custody is transferred from the department to the appointed guardian by operation of law. So you can't have sort of a dual guardianship. It's one person or another person, but it's not two separate people, or in this case an agency and a person. While the goal may be noble, the law just doesn't permit the court to do that. So the trial court was correct in saying I can't do that, even though the parties asked them to do that. Robert D. Was another case in which, sorry about the formatting there, it looks a little goofy. That should be a separate paragraph beginning with child's wishes and the role of guardian ad litem. This was another instance in which a young mother had asked her parents to assume guardianship of a child due to the biological mother's present inability due to immaturity and lack of financial stability to take care of her child, to be the child's guardians, and they agreed to do that. And then she periodically came back to them and said, okay, I'm situated financially, I'm okay emotionally, I can take care of my child. And for under one guise or another, her parents kept sort of delaying that and putting that off, saying, yeah, you're not quite ready, or there's another reason for us to keep the child a little bit longer. It's okay for you to come and see and have time with them, and et cetera, but we don't think we should dissolve the guardian. And the mother just couldn't get them to voluntarily dissolve the guardianship. And this went on for 14 years. She repeatedly tried to get the guardianship dissolved voluntarily, and finally she had to seek an involuntary dissolution of the guardianship, and went to county court to do that, and the court said, the trial court said, in essence, in Nebraska we have the parental preference rule, and the mother isn't presently unfit, and she's made bona fide efforts to obtain custody of this child. She's not forfeited her parental rights by any stretch of the imagination. So I'm going to dissolve the guardianship. Well, keep in mind that this has been going on for 14. So the child's 14. Robert is now 14. If he were being adopted, he would have to give his consent to the adoption. But because this was a guardianship, and because of the parental preference principle being in operation, he was not only not required to provide his consent to dissolution of the guardianship, he wasn't even permitted to testify at the dissolution of guardianship hearing because his testimony just wasn't relevant. Now, you can see that this case probably has its proponents on both the child side and the mother's side and the grandparent side, but the bottom line of Nebraska law here is that she was, at the time she was seeking dissolution of the guardianship, she was not an unfit parent. They didn't have any evidence to warrant such a finding. Therefore, she was allowed to dissolve the guardianship, and the child was not allowed to testify because his testimony was simply irrelevant. Under the dissolution of guardianship involving that parental preference doctrine, the question is who has to prove what? In other words, is the burden on the parent to prove they are fit, or is it on the guardians to prove that the parent is unfit? What happened in this case was that the biological parents divorced. They both agreed that the grandparents should be the guardians. That seemed to be the best plan for the child at the time. Subsequently, the biological mother of the children dies, and the biological father of the children sought to have the guardianship set aside or dissolved. The trial court treated the father's petition for dissolution of the guardianship as a modification of custody and kept the children with the grandparents because he said that because the trial courts found that to be in the children's best interest. And what the Supreme Court said in this case was, again, because of the parental preference rule, the grandparents had the burden of proving that the father was unfit. And they would have had to do that by clear and convincing evidence of substantial, continuous, and repeated neglect of a child, of the children, in order to rebut the presumption that the parent, that the father in this case, was fit. There was simply no evidence that the Supreme Court saw that the father was unfit, and they ordered the dissolution of the guardianship, citing the parental preference rule. And then under Elizabeth H., the question came up as to what constitutes parental fitness. But keep in mind that in Farnsworth, the Supreme Court said that there had to be convincing evidence, clear and convincing evidence of substantial, continuous, and repeated neglect of a child. And then in Elizabeth H., the specific question of what does that mean sort of came up. So again, grandparents were seeking, in this case, guardianship of a child. This was not a dissolution of a guardianship. This was a petition by the grandparents to obtain guardianship of a young child. The mother of the child objected. The trial court found that the biological mother of the child was unfit and placed the child with the grandparents. And the Court of Appeals reviewed the evidence and found that the trial court was correct, that in fact she was unfit. And the factors that they found supporting that finding was that there was evidence that where the mother had been living with the child in the grandparents' home, when they went to look at it, was shocking. There were soiled diapers all on the floor in all the rooms. The crib sheet was so dirty it was stiff. And there were several old formula bottles or baby bottles all over the floor. The mother had moved out of the grandparents' home eventually and went to live with a man with whom the mother and the child lived for 4 or 5 months. When the mother was subsequently deposed during this case about that, she couldn't remember the man's name. And later that same year, after a weekend visit, the child returned to her grandparents with, or to her mother with let me back up. The mother returned the child to the grandparents with an injury which was described as a burn to her nose and to her upper lip. The injury was allegedly inflicted by the baby's biological father. The mother then left the child with her parents, didn't visit or have any contact with her for 6 months. She asked once to have the child return during the 4 years preceding the guardianship action, and she never contributed in any way financially to the child's support. In 2005, when the child was just about a year old, the mother of the child was convicted of driving under the influence. That same year, she gave birth to a son and to another son the next year. She married the second son's father in 2005, left him in 2006, filed a protection order against him while they were still married. And the Court of Appeals said all those facts led to a finding that the mother was in fact unfit as a parent. And they defined parental unfitness this way, and I'll quote their definition. Parental unfitness means a personal deficiency or incapacity which has prevented or will probably prevent performance of a reasonable parental obligation in child rearing, and which has caused or probably will result in detriment to the child's well-being. And they thought that the record provided competent evidence to support, they being the Court of Appeals, thought that there was competent evidence to support the trial court's finding that that the mother was in fact unfit. So this is one of those, this was in contrast to the other cases involving the parental preference doctrine, the parent was in fact found to be unfit. So that's a quick review of some significant cases in juvenile courts in the past several years, and it's been a pleasure for me to talk to you about those. I hope you've gained something from this, and that you'll find practice pointers throughout this presentation that will help you as you represent parents or children.